More post office lawyer stuff. I'm going to read an email containing some legal advice that one of the post office lawyers gave to the post office. And I'll discuss briefly, specifically about the implications for the post office. But it also raises some just general points of interest to do with, can you restrain people from publishing defamatory material? Spoilers, no, you can't. But I'll just read this. It's to Susan Crichton and Hugh Flemington, who are the post office people, and it's from Susan Barty, who's a partner at CMS Cameron McKenna LLP, who were a solicitors firm instructed by the post office. And the subject is SecondSight. And just for people not familiar, SecondSight were the company that the post office originally instructed to do an independent audit of the Horizon system. Now, they took their remit very seriously, and they discovered all sorts of holes, and they had all sorts of rows with the post office about material not being disclosed. They really did threaten to take their ball home, because they said, if you're not going to give us the material you've promised we would have access to, we can't do this. In the end, SecondSight were sacked by the post office. The more sceptical, cynical people may say that's because they were getting too close to the truth. But this is the email. It says, Dear Susan and Hugh, you have asked for my opinion as to whether we can obtain an injunction in relation to the SecondSight report. Because, just this is me talking now, basically SecondSight were hinting and saying, well, we've been sacked, but our report shows that there's a problem with the Horizon system. So it continues. The availability of an interim injunction to restrain a defendant from publication of a defamatory document pending trial is much more restricted in defamation cases, and the courts have consistently demonstrated a reluctance to grant interim injunctions, even where it can be shown that there is a clear intention to publish a defamatory statement. English case law makes it clear that an injunction can only be granted in relation to defamation cases where it can be shown that the statement is unarguably defamatory, there are no grounds for concluding that the statement may be true, and there is no other defence which might succeed. This has been well established as being a relatively low hurdle for any defendant to overcome and, in effect, has meant that wherever a defendant says they will justify any defamatory comments made in a document to be published, or during a proposed broadcast or in a proposed article, an injunction will be refused. This is, in essence, because of the importance attached to the right of free speech. The situation is somewhat different where clear issues of confidentiality and privacy are involved, and if it can be shown there is a threatened publication of private or confidential information. Now, I have to say that is very, very good advice. It's very succinct, it's very clear, and it's very accurate. So what's this injunction thing for defamation? Well, there's a case called Bonnard and Perryman, and that sets out the rule that there shall be no prior restraint in defamation. In other words, it's publish and be damned. So what the court says, even if you know somebody's going to publish something defamatory about you, your remedy is to wait till it's published, and then if you can show it's caused you serious harm, and indeed it is defamatory, then you can claim in damages. But you can't stop somebody publishing that in advance. And as the email states, that is a really hard hurdle to overcome. If somebody just says, look, we're going to justify this. I mean, justify, that's interesting. That's the old language. Now, we used to call it justification, now we call it truth. But if somebody says, I will show that this statement is true, then the injunction won't be granted. Now, the courts have shifted a little bit, and they don't just take your word for it. I will show this is true. They will, ask and say, well, how? What evidence have you got? They won't have a mini trial or anything. That is for the trial. Remember, this is somebody trying to get an injunction pending trial. But they would have to outline. And in, the case of SecondSight, they'll probably say, we've done a report. We're experts. We've assessed all the evidence, and we have come to the conclusion that there is this problem. So we would say our assessment of the Post Office Horizon system is true. I mean, it's interesting what they would actually argue was defamatory about it in the first place. I mean, there's all sorts of defences they could raise. But that's the general rule. Now, can you get around this in any way? People have tried this. They've tried basically bringing an action in defamation but calling it something else. So they said, actually, this isn't defamation, this is harassment. So we'd like an injunction in harassment. But the courts are very wise to that. They've also done it where people have brought injunctions, said, oh, it's publishing private confidential information. But again, there was some football manager where they looked at this and said, no, you're actually just trying to cover up sort of your wrongdoing, so it doesn't count. If, however, it's clear that it is just a try-on, then it's not so much that you can get an injunction at an early stage. I've spoken before about what we call summary judgment and strikeouts. That's where before you get to trial, you say, this case is so rubbish, either it's deficient procedurally, they haven't abided by the rules as to, how you plead a case or how you state a case. Or you say, even if you take everything they say as true. And for summary judgment applications, that's what they do. They assume that the person on the receiving end of the application, when you bring one, you have to say, let's assume everything the other side is saying is true, just for the purposes of this application. We're not saying that is. Then you say, even taken at its highest, this still couldn't be defended. So you might get a claim where somebody clearly makes an outrageous statement, and their justification, to pluck one from America, I accuse somebody of murder. What's your evidence for that? My tarot cards told me they were the murderer. Well, a court may well then say that's not going to stand up in court, so you can get your injunction. But it is very rare. Now, it is easier to get an injunction in privacy or confidence, because the argument there is, well, if we let the cat out of the bag and it turns out we're wrong, then you can't put the cat back into the bag. I mean, I can see why people argue and say, well, I don't see why, damages aren't an appropriate remedy in that particular case. But they are treated very differently. And that's why the email says, well, look, it hints at you might have a different argument if you were to bring this in confidence or privacy. But there are defences to that, you see, because we have this saying, there is no confidence in iniquity. In other words, you can't use privacy and confidential and confidence as causes of actions to cover up your own wrongdoing. Or, another exception is, you can breach confidence to correct a false impression. So even if, say, there's a contractual or common law obligation on you not to reveal this information, but then the person at the heart of that, they are saying something that is demonstrably untrue, if you can refer to this, then you can say, well, actually, I am going to breach the confidence because you are putting out falsehoods to the general public, and we can prove it by reference to this material. So you can't use, like I say, confidence to protect wrongdoing. So clearly the Post Office were always in trouble with this SecondSight report. But, as all the judgments have said before, the Post Office were more concerned about public relations and, reputation management than they ever were about the actual legal merits of any cases. So there you go. Like I say, I just thought you might find that interesting, and it's of general applicability. So remember that if somebody is threatening to libel you, chances are you can't get an injunction to stop that. But if it's private, confidential information, you might be. There is one case, Asher McKenna, that says where it's a sort of a mixed thing. This was a case where somebody's nanny did a sort of tell-all article. And obviously in the employment contract it was, you're working in our house, you have access to all our secrets, you will not disclose them. Now, what they said is, well, these allegations are all untrue anyway, because they're all about how, we're terrible parents and things like that. But what the court said there was, although there were some defamatory allegations, fundamentally the issue was this was somebody breaching their employment contracts. Because the allegations were denied, they couldn't use it as they tried we're just, doing this to, reveal wrongdoing. It's in the public interest to relate this information. And they said, well, at this stage it might not be. So let's have a full trial on this. If it turns out your allegations are correct, then yeah, that's fine, you can publish. But pending that trial, we will grant an injunction, because I've done a video on injunctions, and I'll try to remember to link to it in the end screen. But we have this balance of convenience test. In other words, when looking at whether or not to grant an injunction, we look at, if we get this wrong, who suffers the most? So if we grant an injunction and it turns out we shouldn't have done, what will be the loss to the person? Versus if we don't grant this injunction, it turns out we should have done, what's the loss to the other person? And in this case, it was, well, if we don't grant this injunction, this is all going to be out there. And even if we have a trial, it's too late then. People will say no smoke without fire. People will just read the article. They probably won't read the law reports. So this is also this idea with injunctions of preserving the status quo. But like I said, that doesn't apply to defamation. It is one of the anomalies. So there you go. As always, hope you found that vaguely useful, vaguely interesting. If you did, please consider liking, sharing, subscribing, etc. Cappy Barrister and Lord Luberduck say hello. They're to one side today because I was doing a defamation hearing by video link. And I thought, much as people like Lord Luberduck and Cappy Barrister, they probably shouldn't be on screen. Not least because Cappy Barrister actually looks a lot smarter in his robes than I do, as indeed does Lord Luberduck.